We are talking about what is commercial utilization. So, commercial utilization is defined in Biological Diversity Act as end uses of biological resources for commercial utilization, such as drugs, industrial enzymes, food flavors, fragrance, and there are a lot of examples there, but does not include conventional breeding or traditional practices in use in agriculture, horticulture, poultry, dairy farming, etc. So, which basically means that when you are converting, when you are using a biological resources to make a drug or to make a industrial enzyme or food flavor or fragrance, then that is commercial utilization. And the main part of the definition is what is whether that particular thing is an end use of the biological resources. And now this and you keep in mind the exemption is that it does not involve conventional breeding or traditional practices in agriculture, horticulture and all. So, if the section 3(2) persons are accessing the biological or obtaining the biological resources occurring in India for all these purposes, then they have to apply to the National Biodiversity Authority. If that is commercial utilization, and also there is another regulation, if this biological resources is used for biosurvey or bioutilization, then also they have to apply to the National Biodiversity Authority. So, what is biosurvey and bioutilization? It is basically survey or collection of species or subspecies, genes, components, etc., and maybe using if you are making an inventory of the species that you have collected, then that also requires permission, and it is not just permission, it is prior permission from the National Biodiversity Authority. Linking it with the elements which says that the free prior informed consent should be prior to the access. This prior permission has a very important significance. The word prior has an important significance because before accessing you have to approach the National Biodiversity Authority. So, first regulation is with respect to section these activities. Also there are other regulations for which you need National Biodiversity Authority's permission. Also you need the state biodiversity's permission. Under the Act, you have two regulatory bodies, that is the National Biodiversity Authority and you have the State Biodiversity Board. The National Biodiversity Authority will be looking after section 3, section 4, section 6, and the State Biodiversity Authority will be looking into section 7 of the Act. Under the regulatory part, they have other parts as well which are elaborated in the Act. So, section 3 we have discussed. Section 3 means whenever a section 3(2) person wants to collect or obtain biological resources for the three purposes that we have discussed, they have to approach the National Biodiversity Authority and they have to get the permission from the National Biodiversity Authority. And section 4 says that when you want to transfer, who wants to transfer? Anyone who wants to transfer to a section, the research result of a project, then you need the permission from the and transfer it to a section 3(2) person, then you need the permission, prior permission from the National Biodiversity Authority. So, when you are transferring research result relating to any biological resources occurring in India or obtained from India, this occurrence is very important because India should be the provider country and for monetary consideration or otherwise. So, if you are transferring the research result, also you have to apply to the National Biodiversity Authority before such transfer, because you need the prior permission from the National Biodiversity Authority. Now, National Biodiversity Authority has another regulatory power, that is with respect to section 6. What is section 6? Section 6 means that you need whenever you are applying for any intellectual property, be it patent or anything else, you need the prior permission from the National Biodiversity Authority. So, this patent should be, so this intellectual property should be over an invention based on a research or information on a biological resource obtained from India. So, if you have done an research on a biological resource obtained from India and if you have an invention, then you have to apply to the National Biodiversity Authority. And then you have, but there's a proviso which says that even if you have applied, this is with respect to patents only, this it says that even if you have applied to National Biodiversity, to a patent office, it doesn't matter. Before the grant, they use the term sealing, but it's now sealing, that process is gone. Now before the grant, they have to get the permission from National Biodiversity Authority. So section 6 has certain problems, because you say before you apply for any intellectual property rights for an invention. So whether the inventions, other inventions like your geographical indication, other IPRs like geographical indicator, or your copyright, whether these intellectual property rights are included within the section ambit of section 6 is kind of contentious, because this, after the intellectual property rights, the provision, section 6 provision uses the word invention. So whether it is confined to patents, or like the plant varieties patents, like breeder's right and everything, or whether it includes copyright or geographical indicators, is something that we have to, some guidelines have to be given by the parliament itself, because it's in the legislation. But there are exceptions to this section. The Plant Variety Protection Act of Indian Plant Variety Protection Act does not need permission from this, because it already has this existing benefit sharing mechanism. And now we have kind of covered section 3 and section 4 and section 6. And what is section 5 all about? Section 5 is about an exception to section 3 and section 4, which says that collaborative research projects will not require the prior permission from National Biodiversity Authority. Collaborative project, if it falls in kind of like complies with all the conditions that are listed, that is, if there's a guideline which says that there's a guideline that is issued by the central government, if your collaborative research project comply with that guideline, and if you have got approval of the central government, then you don't need the permission of National Biodiversity Authority under section 3 and section 4. So this is section 3, section 4 and section 5 and section 6. Now we come to section 7, which is the regulatory power of the State Biodiversity Board. So what is the regulatory power of the State Biodiversity Board? The it says that the State Biodiversity Board should be, no persons are Indian citizens, or the body corporates enlisted and incorporated in India will not will have to give prior intimation to the State Biodiversity Board if they are obtaining any biological resources occurring in that particular state. So this is section 7 is confined to Indian citizens, and also section 7 is confined to certain activities. Indian citizen does not require to give prior intimation. It's different. One is prior intimation, another is prior permission. So the Indian citizens or bodies and Indian corporate bodies won't require permission, but it only requires intimation, and this intimation is only for certain biodiversity activities, that is whenever they are using commercial utilization. Undertaking commercial utilization or undertaking biosurvey or bioutilization for commercial utilization. So that is your section 3, 4, 5, 6 and 7. Now that is relating to your access. We kind of talked about the concept of access and benefit sharing. Now how does the benefit sharing come into picture, and what is the mutually agreed terms that these guys can do, and who is the appropriate body giving the consent for this? That is discussed in section 20, 19, 20 and 21, and benefit sharing is kind of related to or given in section 21, and section 21 it says that it is a mandate of the national biodiversity. Benefit sharing is already defined in your biological diversity, and it says that it is determined, benefit sharing is a benefit sharing determined by National Biodiversity Authority under section 21. Section 21 refers to section 19 and 20, and section 19 and 20 refers to section 3, 4 and 6. And section 20 is when anyone has to wants to transfer this permission they have obtained under section 19, that is 3, 4 and 6. So, with respect to these, the National Biodiversity Authority, it has an obligation to enter into to mutually ensure that there are terms of a condition which kind of ensure that equitable sharing of benefits arising from uses of the access biological resources will be ensured. And this equitable sharing of resources should be in accordance with mutually agreed terms. Who will be the parties? The parties will be the person accessing, applying for the approval, and the local bodies and the benefit claimers. Benefit claimers are people who are conserving the biological resources, or who have the who have been keeping the information related to biological resources. The term is also defined in Biological Diversity Act, and these are the people who have to be involved in the mutually agreed terms. And what are the benefit sharing modes of benefit sharing? They are non-monetary and not monetary, which we have already told in the previous discussion, which is like if you want to share in the profit, or if you want to set up a venture capital, or if you want to set up a unit here, all this will come under benefit sharing. And all these should be in accordance with the mutually agreed terms, which basically means that the National Biodiversity Authority has to consult the local bodies and the benefit claimers. And also there is another provision in section 41 that says that the biodiversity management committees, which are also a statutory body established under the act, have to be consulted whenever they are accessing, whenever NBA or SBB is making a decision over the access of these resources from within their jurisdiction. So they have to be consulted also, and a lot of times local bodies will be BMCs will be consulted instead of the local bodies. That is what the practice have been. So this is how the entire regulation and access mechanism under the Indian regulation goes. Also you have, if any one of you, I mean if these provisions are violated, then it is a cognizable offence. Now we can kind of like skip to the case studies, which is like, first of all we will discuss a Kani tribe case, which is an example for bioprospecting. The other one is a BT brinjal case, which is a example of biopiracy. So in Kani tribe, what happened? It happened before, much before the CBD and all. What happened was these guys wanted like a, and there were no provider country or like there were no other countries. It happened within the country. So Kanis are like a small tribal groups in southern India, and they had a particular traditional knowledge with a particular plant, which is called Arogya Pacha. So what happened is the Tropical Botanical Garden and Research Institute, they kind of like went and they kind of came to know about this particular knowledge, and they kind of decided that there is a scope to kind of like make a product out of this particular biological resources and also the knowledge associated with it. So they kind of like made a contract with the Arogya Coimbatore Ari Vaidyashala, and there was an agreement, like just like a mutually agreed terms and all. They had an agreement wherein the profits were also given to these Kani tribes. They had a share in the profits, and also these guys were supplying the biological resources to the particular company which developed the drug, which is the drug is called Jeevani, and this company is called the Arya Vaidyashala. That is a Kani tribe example. Now we have the BT brinjal example, which is a case of biopiracy, which is when the section 3(2) company like Mahicom, Maharashtra Seed company, because it had a foreign shareholding capital, it had Monsanto had invested in this particular company, so it fell under the definition of section 3(2) company. They accessed local varieties of brinjal from Karnataka, and without the permission of National Biodiversity Act, for developing for doing research and also for commercial utilization, because they were developing a BT insect resistant BT brinjal variety, for which they haven't had received the permission from the National Biodiversity Authority. So the National Biodiversity Authority, what they did was they filed a complaint against it. The Maharashtra Seed Company and also the University of Agriculture Sciences, which kind of gave the local brinjal to the company. Also there was like a party who were facilitating this entire process, that party was also made accused, and this case is still pending in the court, but this is a case of biopiracy that is there. So today we have discussed the concept of access and benefit sharing and regulations relating to access, regulation relating to benefit sharing, elements of access, elements of benefit sharing, and the international and the national regulations, important regulations, and also certain case studies. Hope everyone understood, and thank you.